jurisdictional challenge, but I changed it a little bit. And the purpose of this document, it's pretty sweet. Now, rule number one, ladies and gentlemen, this is not legal advice, and this is not a template. I don't like the concept of a template. You have to make it your own. You have to understand there's reasoning behind things that are in this document, and you need to adjust it for your circumstances. For example, civil matters are way different than a criminal matter, so you're going to have to change language, things like that. But what this does is this really puts the court on a test, and this is meant for that first appearance, or something you put in before your first appearance. If you come to me and say, well, what about after the first appearance? I said, well, you know, there is a provision here for that, but you've already begun to do things that contract with the court, and we want to avoid that. And so we put the burden of proof on them, not us. That's the key to this. Once you've already gone in there and entered a plea, it's a little more difficult to do. But if you get this, know that if you do this, you're going to be challenged and tested. So be prepared for that, okay? I can't tell you what's going to happen. People ask me all the time, what's going to happen? I go, I don't know. Maybe the sky's going to be blue tomorrow. I don't know what's going to happen. But I do know that if you understand what this says, as opposed to just know what the words are, understand what you're saying here, you'll do far better with this, because you've got to back this up with your action. It's not just a magic document to just be thrown at somebody. It's a document that has to be supported by completely understanding it and using it and staying on point. So let's get into this. So with a daily document like this, I want to put it under the postal jurisdiction. So I'm going to put a $1, just a standard $1 stamp, any $1 stamp, a blue thumbprint, bleeding onto the page and the stamp, and with a signature across it, formatted like colon first, hyphen middle, colon last, colon, or period, whichever format you prefer, but that's the way you write your signature across it in blue ink, and the right word copyright, copy, claim. What that does is it puts this under a postal jurisdiction in case you need to enforce it, and they don't like that. Too bad for them. And also, it makes you the postmaster of the document. So this is kind of a blending of the syntax concept along with conditional acceptance, along with discovery requests. I built this document putting all that into one document. I'd like to see some of you probably modify it a little bit. You know, the wording could change. But, you know, there's going to be, like, for example, if the United States or the state of Texas or the other party, you know, ABC Bank, maybe they're suing you for a credit card, or a child support agency, or whatever it is, whoever's coming after you goes here. Formatted according to the court heading. Go look at the court's headings and how they do it. Use their format. And I call this motion for discovery, conditional acceptance, motion to dismiss. Now, I don't like to put everything into one document, but this could, if there ever was a one-size document that might fit a lot of situations, this could be an interesting way to approach it. Filed using registered mail number, so that means I'm going to register mail it, send it registered mail to the court, to the clerk. Okay, got to go to the clerk because it's not going to get filed if you don't send it to the clerk. And but that registered mail number also registers it under the Universal Postal Union as a postal claim. So you got to establish that jurisdiction. That's what you do here. So motion for discovery, conditional acceptance, motion to dismiss. Now, let's just say that this is a criminal matter, so you got to do a plea, right? It says, I accept everything you've offered upon the following conditions. I can offer a plea of guilty to the facts, but innocent of a crime. Now that's really going to mess them up, because they need you to say guilty or not guilty and create a controversy. What you're saying is, yeah, whatever the facts are, they might have happened, but that doesn't mean I'm guilty of a crime. So this is a very good, creative, alternative way to entering a plea. They can't say you didn't enter a plea, and you're saying guilty to the facts. My gosh, I don't want to plead guilty. That's not what this says. You're just not playing. You're giving them your contract. All right. Now, if it's a debt, you might say, well, not guilty or innocent. You say simply not liable for the alleged debt as applicable or something. You might change the wording if it's a debt claim. And then upon proof of claim by the complete answers to these discovery items. Now, discovery is one of your best tools. We use it a lot in a lot of situations. We use it pre-trial in an administrative process. That's a discovery process. But it's not discovery until it's in court. Well, now we're talking about something that's in court, you know, beginning a process. You've been notified of a suit, or you've been noticed, you've been arrested, you know, whatever. You know, you get out, you get your documents ready, you put it in, and then you do your appearance. So, one, condition number 1, provide admissible evidence and the name of a witness who will testify that I am a decedent. Now, I want to point out that when I'm using this term, provide admissible evidence and name of a witness. Evidence is not admissible unless there's a witness to accompany it. You go to court and the other attorney starts talking, it's all hearsay. You should object and say hearsay. Well, this addresses that too, but this is pointing out we're going to deal with admissible evidence today. That's your rules. Okay? And that's fair. That's a fair thing to ask for. And I don't want the name of a witness who's going to testify. I need to know who my accuser is and who the witnesses are. I'm not going to proceed until I know that there's a witness. Because if I'm just there before a judge and a prosecutor and there's no witness, then there's nobody making a claim. It's just you're the one going along with it. So you start that out. And testify that I'm a decedent. Now what does that mean? This has to do with the all caps name. The all caps name is the name of an estate. But estates only are created for decedents, people that are dead. So they created a fictional entity. It's not truly dead, it's just not living because it's an entity, like a business name. Okay? That's what they're doing. And they always put that name on the document, right? Up in all capital letters or something with a middle initial. Sometimes they use upper and lowercase, but a middle initial. Well, guess what? That's still the formatting of a decedent. And then, 2, provide admissible evidence and the names of witnesses, again, who will testify that my given original name is not Doe John Henry. And that's the one that's on your birth certificate or however it's formatted on your birth certificate. Use that one. I don't know. You use the one that's on there. And by the way, that's through the hospital record, not the state record. There's 2 records. One from the hospital. It'll be a printout of that. Sometimes you get that at the state, but you'll see that it look like a hospital form. And they'll put your name last, however it's formatted, you use that. As opposed to the estate or trust name on the documents listed as John Henry Doe. So what you're saying here is there's now a mistaken identity, and that's a great way to get a case dismissed. Provide admissible evidence and the name of the witness, there it is again, who will testify that I have accepted liability for the named decedent as surety. Who's going to say that I've ever said I would be the surety for the decedent? That means the liable party. This is all about trust law, trust language. Provide admissible evidence in the name of a witness who will testify that I, Doe John Henry, whatever name it is that's on that original birth record, am not only the beneficial interest holder in the estate named John Henry Doe, as named in this matter. Lacking of providing this would stand as evidence of a wrong party named. Okay? I might change that wrong party claim. I'm going to claim. Somebody's actually working on this today, kind of revising it, so that happens. Because that's actually a defensible issue. Then provide admissible evidence and the name of a witness who will testify that the judge and prosecutors in this matter are in fact not the trustees and liable sureties for settling and closing this account upon my acceptance. In other words, you're accepting it only on the condition that they are staying in their position of sureties and trustees. They are the public trust. They're supposed to do these things. That's where HJR 192 comes in. This is where you're actually using HJR 192 properly. That's the issue where the public servants are supposed to pay the public debts. So I rebut any previous presumptions to the contrary based on previous appearances. I'm going to say double word there. Any presumptions to the contrary based on previous appearances of filings and disclaim being trustee defendant as named. Now this one's kind of covering you if you've already answered to the name accidentally before. Okay? And when you answer to the name, you're saying I am the name as opposed to I'm the beneficiary of that.